Good afternoon, everyone. It's a great pleasure to welcome you to the 5th episode of the YouTube Talking Evidence series. It's going to be on stereotypes and the polluting effect of stereotypes on evidence before human rights adjudicating bodies. My name is Marie-Bénédicte Dembour. I am a professor of law and anthropology at the University of Ghent, and I direct a research project funded by the European Research Council called DISSECT, Evidence in International Human Rights Adjudication. Today, it's my great pleasure to introduce the two speakers who are going to talk to us about this theme of stereotypes in evidence. One is Elena Ghidoni, who is a postdoctoral researcher at Deusto University and who has worked extensively on gender stereotypes. That was the topic of her PhD. And the second speaker is Roels, who is a PhD researcher at the University of Ghent at the Human Rights Center, and who is actually working on rape, on the application, in a sense, of the reality of rape myths, how we can transfer what we know about rape myths in the adjudication of asylum claims. So it's a pleasure to have the two of you here. And I will first ask you to present yourself a little bit more to our audience and to explain in what sense you work on stereotypes in your research projects. What's the role of stereotypes? Why are you interested in this topic? Why do you find it important? So either of you, maybe Elena, maybe you start.
Yeah, with pleasure. Thank you, Marie. Thanks for inviting me. It's a very exciting opportunity, and I look forward to this discussion. So as you already said, I'm working as a postdoctoral researcher at the Human Rights Center here at University of Deusto. And I've been working on judicial stereotypes, particularly in the case law of the European Court of Human Rights. And I've been focusing mostly on stereotypes at the intersection of gender, race, migration, and class, looking at the cases that relates to family relations, broadly speaking. So not only family law, but also when the family notions are used, for example, to ask for a reunification or to challenge deportation based on Article 8, for example. And I looked at stereotypes from anti-discrimination law. So my focus is on the impact and on the role of stereotypes in the theory of anti-discrimination law and how to conceptualize them as forms of discrimination. And whereas in the thesis I've been looking at the ECHR, now I'm focusing more on the CEDAW and the decisions of the CEDAW committee on gender stereotypes, and particularly on the impact of stereotypes on the evaluation of evidence, which was a tiny part of my dissertation that I'm now trying to explore a bit more. And okay. I've been also working closely with Dolores Morondo, a colleague from the institute. So I say it now because her name might appear today.
Okay, well, you're the perfect person to be invited by DISSECT, and we look forward to hearing more from you. And Laura, can you explain a little bit what your research is about?
Of course. So, Marie, as you introduced me, I'm a PhD researcher at Ghent University, I specifically work on sexual and gender-based violence in asylum procedures. And that's why I'm both located at the law faculty within the Human Rights Center and the Migration Law Research Group, but also at the medicine faculty, because I focus both on asylum law and sexual and gender-based violence. Specifically, I'm looking at persons who flee sexual and gender-based violence and apply for asylum in a host country. And I'm looking at these procedures both at the national level with a case study on Belgium and the European level, in which case it turns to non-refoulement procedures, of course. So that's what I will be focusing on today mostly. So the European Court of Human Rights and their non-refoulement cases related to gender. The role of gender stereotypes in my research, as Marie said, I focus on rape mythology. The concepts will come back later, I guess, to how these two relate, but I talk about gender stereotypes by specifically framing them as rape myths. And I specifically do this because they originate from the criminal justice context, and rape myths have been identified a long time ago, so I can borrow a lot of expertise from the field of rape mythology that turns out to be very useful to identify specific gender insensitivities in asylum procedures. So it's a very practical way of looking at the issue. And for example, there have been designed instruments called rape myth acceptance scales, by which you can specifically measure someone's level of acceptance of these myths and stereotypes. So all these very practical advantages of this theoretical framework led me to focus on them in my PhD research, specifically because in asylum law, but also in non-discrimination law, this whole notion of gender-sensitive procedures often in practice appears to be a very vague concept with little little limitation or little definition in international law. So their rape myths turn out to be a very useful concept.
Okay, can you give us some concrete example of rape myths? What do you mean by rape myths in practice?
Of course. So rape myths, they've been defined as stereotypical or false or prejudicial beliefs about rape victims and rapists in the 80s, so a long time ago. And I specifically extend this concept to other forms of sexual and gender-based violence than just rape. But a specific example would be, for example, that only specific types of persons would be vulnerable to sexual and gender-based violence. We tend to think of young, uneducated, vulnerable women who hang out at bars or take a dark street home alone. These very, very old stereotypical views we have. These, of course, well, they are a bit outdated now, but the core of them still appears in case law and decisions, and even in general society today. And I don't know, Marie, I can give you a specific example of case law of the European Court already, or do we?
Maybe not now, but so there is this myth that the victim of a rape would present in a particular way, would be a particular kind of person. That's one example. Is there any other example of a rape myth that you could also give us so that we have more idea of what you're talking about?
Of course. There are also the ones related to the narrative on how someone and how quickly someone discloses about sexual violence, for example. So we expect persons to have experienced such a great injustice and such pains that they would disclose immediately, whether this is someone in their immediate surroundings or to the police, that they would seek help immediately, and that they would remember details because it's such an extreme experience. They would disclose in a consistent manner, in a chronological manner. They would remember many details and so on. So these are elements that in practice don't turn out to be true at all, partly because of the effect of trauma on memory, but also the influence of shame and fear of retaliation and the sensitive nature of this type of violence. all of these resulting in the fact that the numbers differ according to the context, but between 4 and 7% of victims and survivors which formally report to the police, which are very, very important clarifications to make, of course, when you have to make decisions on how credible someone's story is, especially when they didn't go to the police, for example.
Okay. So there are myths, for example, that the victim would go directly to the police. The victim has not gone directly to the police, and as a result of that, they would not be believed, including by a judge who would be in charge of adjudicating on their case. Elena, are these myths that Laura has been talking about, are they stereotypes, or are stereotypes something different from myths?
Yeah, actually, listening to the description that she was giving now, there are many resonances with the concept of stereotypes that I use normally. So all the example that she made about the behavior that is expected, the kind of vulnerability, or the specific type of person that is a credible victim of rape, of gender-based violence. These are all examples also of stereotypes. And at some point, Laura, you define myths as either false or prejudicial or stereotypes. So I sense that there are some elements of the notion of stereotype as well, because we usually refer to the definition provided by Cook and Cusack, whereas stereotypes are generalizations about the role or the traits or the role that a member of a group have or should have. And then they are usually classified as either based on prejudices or statistically incorrect. But there are also statistically correct stereotypes that are still harmful. So there are some elements of the classifications that you provided of myths that are basically very, very similar to how we conceive stereotypes. So I don't see differences in this sense, even though the concept of myths suggests more, to me at least, suggests an idea of false or unbelievable or rebutted by facts, by evidence. But still, if it's used also as a synonym of stereotype or generalization or prejudice, I guess we are moving in the same area of concepts.
Okay.
In the end.
Okay, so concepts which are, if not exactly the same, overlapping, and then in what both of you are talking about, there is this relationship, this ambiguous relationship to truth, in the sense that if you use the word myth, it may suggest that actually they are mistaken. If you use the word of stereotype, it may suggest that it's a generalization which maybe works in some cases, but not in all cases, because by definition, all members of a particular group are not going to behave in exactly the same way. So there will be individual differences, and the stereotype, even, I mean, because you said a stereotype was potentially based on prejudices, but I guess a stereotype can also be based on a certain reality that a certain group will tend to work to work or to behave or to present. I don't know which word to use, but in a sense to be in a certain mode, but not in all cases. And so I guess that there is kind of for a stereotype, a presumption maybe for a myth as well, because when Laura, you were saying, well, not all rape victims go, well, a victim is not going to go to the police immediately because it's too overwhelming, too raw, maybe too shameful, maybe too traumatic, to maybe also elements of fear. Or we cannot say that the victim is never going to go directly to the police, because of course you will have the exception, and I suppose some victims are going to go directly to the victim. So the problem is, I guess, that we make assumptions. So maybe can one of you come up with the problem that you see stereotypes bring in terms of getting how a case, the facts of a case for a court? Where do you see the problems?
I could start, Elena, if you're okay. Yeah, I think you already pointed to the core of the problem in what you said before, that stereotypes are not necessarily wrong. I do think that stereotypes, in a sense, in the core of it, are based on some truth. The problem is that this one truth is externalized or is generalized to be the only truth. And so, for example, what I said before, it might well be that statistically, the majority of rape victims are young, poor, uneducated girls. But if you use as a decision maker in legal proceedings this as the standard to measure whether or not someone would be at risk of such violence or need protection, then we have a problem, because you interpret the ideal victim very narrowly to this one truth that you generalize. And I think maybe here it's interesting to mention one of the more recent cases of the European courts, a non-refoulement case, which was about a 22-year-old Afghan man who lived in Afghanistan until he was 5. He fled, well, no, he left the country after his parents died. He had two persons taking care of him who also died. So he was an unaccompanied minor in Iran at one point, where he was raped by 2 men. He then fled, applied for asylum to Finland and was denied protection and so on, and eventually ended up at the European Court, where, if I may, a very short quote
Go ahead.
of the European Court, where they stated that the sexual assault took place in Iran years ago, and the applicant is now a 22-year-old adult man, and as an adult single male, healthy and capable of work, the applicant cannot be considered particularly vulnerable to further sexual exploitation, even in the absence of any support network. And in addition, this person was diagnosed with post-traumatic stress disorder and depression. So you see in this context that this applicant, this male applicant, is measured against the standard of the ideal victim of the poor and educated young woman, and therefore is denied protection, whereas he might very well be in need of it. So I think here, yeah, the problem is, I'm not making an evaluation on whether this person should, in the end, taking all the elements of the case into consideration, should have received protection. But of course, you can see if this is one of the reasonings that is used by the court, and a decision contains multiple of these, or almost exclusively stereotypical reasonings, then of course there's a problem with the outcome of the case. So I think, yeah, using the word polluting that we used in the title, the more stereotypical types of reasoning you see in one decision, the more polluted the outcome is, I would say.
Okay, thank you. So if I understand well, this case that you mentioned to us, what was its name, by the way? The title of the case?
It is MH versus Finland.
Okay, thank you. It's someone who is whom the state, so in this case Finland, wanted to deport back to Afghanistan, I assume. And this person was saying, well, if you deport me back to Afghanistan, I'll be at risk of inhuman and degrading treatment, including because I'm vulnerable and I have I've been subjected to rape in the past, and I feel that you know, inhuman and degrading treatment is something which will potentially again happen to me.
Exactly.
Yeah. Okay. Thank you. Elena, do you wish to add anything about this idea that stereotypes pollute evidence before the judiciary?
Yeah, I definitely want to say something about it, because I've been looking into the way stereotypes act in judicial reasoning, and specifically in the evaluation of evidence. And I suggested to compare them also to the functioning of legal presumptions, which are legal mechanisms that have a specific function in the judicial reasoning, particularly when there is no direct evidence available. And stereotypes display similar features of legal presumptions in the sense that they, and particularly of absolute presumptions, in the sense that they prevent the establishment of facts in some circumstances. And I think it is particularly evident in some cases of decided by the CEDAW committee. For example, the González Carreño versus Spain case, which was decided in 2014. It was the case of the murder of a young girl by his father during an unsupervised visit. And the mother of this little girl had reported domestic violence several times to the police, and so there was evidence also of violence, because it was witnessed by the social services and the police as well. And nonetheless, the domestic courts were unable to protect the victim. And in this case, we can see how, even though there is evidence to suggest the risk of escalation of violence and the existence of domestic violence in the first case, the domestic court in the González Carreño case, also based on reports from the social services, considered that this risk was not severe, was not substantiated. And this is how the stereotype, gender stereotypes, justify somehow the conclusion as to the no risk of violence, no risk of escalation, even though there is evidence that suggests the contrary. And this is a mechanism that I think is particularly interesting if we want to understand how stereotypes work in practice. I don't know if I explained it clearly.
In this case, what was the stereotype at work which prevented?
There are many. First, that women reporting violence are unreliable, that women often lie about domestic violence, and they easily fabricate accusations for whatever reason. And that also and in this case in particularly, there was also this understanding that a minor, the presence of a father is always beneficial to a minor, even though this parent, in the case the father, has proved not to be a good father, because he has been perpetrating violence against the mother in front of the child, because he was also behaving in an inappropriate way with the child during the visits. And nonetheless, the social services in this case concluded that he had the right to these visits.
Yeah, I guess we are in an area which is by nature difficult, because in fact there are indeed different interests at play, and not just interest, but also ideal situation. So it's so I can see that one should not go by the stereotypes, and then the whole question becomes, when do we have evidence about something? Because it's true, you cannot really prevent a father from seeing their children, or the children cutting the children from their father because of an allegation of violence. So it's all about, what's the evidence and how do we act about the evidence. But I think that's very, very interesting. So what do the institutions do when confronted to this problem that myths or stereotypes come across as the truth, the whole truth? They're not the whole truth at all. Actually, they were the opposite of the truth. What do they do? Maybe, Elena, can you talk to us a little bit about HACIDO, which is the committee which implements the International Convention for the Elimination of Discrimination against Women? How does CEDAW manage stereotypes? What do they do about it?
Yeah, I think, of course, CEDAW is a reference point because it has provided the first legal framework to address stereotypes worldwide through Article 5A, particularly Article 5A in conjunction with Article 2. That together impose an obligation to take to member states to take all measures to abolish or modify laws and practices that constitute discrimination, including stereotypes. So, and the committee has been also working after the adoption of the convention to develop the content of these obligations, not only through the general recommendations, but also through the decisions on the individual publication. So, for example, in the general recommendation number 25, the committee explained that the state has this obligation to address prevailing gender relations and the persistence of gender-based stereotypes, not only through individual acts by individuals, but also the stereotypes that are embedded in law and legal and societal structures. And then more recently in 2015, and I think this is the general recommendation that is most important for stereotypes and evidence, the number 33. It has recalled some of the principles that it has already laid down in the Vertido case, a landmark case, so to say, in anti-stereotyping, which is that judges cannot apply rigid standards about what they consider to be appropriate behavior in the case of gender-based violence. And in this recommendation, the committee also warns about the effect of stereotyping on the credibility of women, whether they are parties or witnesses in proceedings, and that this polluting effect may lead to a lack of impartiality from the judiciary and miscarriage of justice. And I think that recently the cases that have been decided by the committee also show a clear understanding of how stereotypes impair the evaluation of evidence. For example, selecting evidence from one party over the other, or excluding relevant evidence, whereas irrelevant circumstances are given the priority, or considering the author's allegation non-credible without any convincing motivation or explanation, but only based on gender stereotypes. So I think this is very important, and the committee, the CEDAW committee, has been doing a very important job on explaining how stereotypes work.
Okay, so what I retain from it is, from what you've said, is one, stereotypes, in a sense, can replace evidence and make assumptions about what happened which are wrong, and then displays the correct evidence, because they act and don't allow the evidence of the proper which reflects what happened to shine, because in a sense it obscures what you see.
Yeah, exactly like that, because in the end they provide a narrative, a ready-made narrative about what could have happened, that prevents the adjudicators to effectively understand or look for the evidence. Yeah,
because also it looks plausible, because as it feeds into our stereotypes that we work with, it looks like, oh yeah, this must be correct. This must be what happened.
Exactly.
Okay, so you mentioned this case Vertido. Can you talk to us a little bit about it? What was that about?
Yeah, Vertido versus Philippines was a case of 2010. And it's considered a very important case, a landmark case, because for the first time, well, the author's representative managed to explain carefully which stereotypes were taken into account by the domestic court, and what was the impact of each of these stereotypes on the conclusion of the domestic court. It was a case. It was a case of sexual violence at the workplace, and the stereotypes concretely were, for example, that women should physically resist sexual assault at every opportunity, which is something that Laura also mentioned before. So, if a woman doesn't resist fiercely an attack, then she should probably have consented, or we can presume consent, or that women are inherently untruthful. So it is likely that they fabricate allegations of rape, which is, of course, false, and it is not the case, especially since we see how difficult it is to prove violence. And another stereotype that was challenged in this case was the fact that older men lack sexual prowess. So since the perpetrator in that case was an older man, it was less credible that he would be able to assault the victim. And the CEDAW committee, in this case, succeed in recognizing that the stereotypes had an impact on the adjudication of the case, and that this impact prevent the victim from accessing redress, and then it amounted to discrimination. So it's a particularly important case.
Okay, so what I retain from what you're saying here is that the stereotypes themselves led the domestic court to act in a discriminatory way against women. That was, if I understand well, the view of the committee, the view of CEDAW. Yeah. I mean, there is another thing which is extraordinary about CEDAW, which I learned during a symposium that DISSECT held in last month. And this is that CEDAW asks every member who is part of its committee to actually read about stereotypes. And you were part of this symposium. And I know that, I mean, for anyone who would wonder, that we have been given permission to actually mention this fact. Can you tell us a little bit about that book, which everyone has to, well, I don't know if they probably not examine about it, but they strongly encourage to read the book as they start working for CEDAW.
I was also positively surprised by this news that they are provided with a copy of this book that is called Gender Stereotyping, Transnational Legal Perspectives, which is a milestone in the study of stereotypes in international human rights law, and was written by Rebecca Cook and Simon Cusack in 2010. So I think it's indeed very positive that that the committee is taking steps to understand what are the terms of the debate regarding stereotypes, and from also different jurisdictions, because the book really engages with different cases from different jurisdictions, and it also elaborates on the type of obligations that should be drawn from the articles of the CEDAW, and also on the definition of stereotypes themselves. So it is indeed an important reading, and it was a good news to know this.
Okay, Laura, can you imagine the president of the European Court of Human Rights asking all judges at Strasbourg to read that book by Rebecca Cook?
Yes, good question. I don't know which books they do or do not read, but at least I know it's not, well, if they would read it, it's not reflected in the case law, unfortunately. Yeah, if I hear Elena paint a fairly positive picture of CEDAW being encouraged to inform themselves about these stereotypes and seeing them actually challenge stereotypes used by national courts, that's in stark contrast to what we see at the European Court, unfortunately. I think what my research is about it's about identifying the use of such stereotypes and myths, not only by national courts, but also by the European courts. And I think the point here is that rape myth acceptance is everywhere in our society, in general society, but also in legal procedures, and unfortunately even the legal procedures at the last resort in human rights bodies. And I mean, so if you see that national courts use the stereotypes, then the next step is that the European Court replicates them, unfortunately, in its case law. So we cannot even start to look at whether the stereotypes are challenged in an effective way or not, like you did so beautifully in your paper. It's just, well, unfortunately, the stereotypes are replicated at the level of the European Court itself still.
You've already given us one example through the case of this asylum seeker against Finland. Would you have a second example that you might be able to give us, Laura?
Of course. There's one case, for example, I should look into the exact name of it, but it's a case about a woman who was fleeing domestic violence and forced marriage. I think from Somalia, but I'll get back to it in a minute after I looked it up. And here we see that she was forced by her uncle, amongst others, to enter into this forced marriage. So she was not only fleeing domestic violence by her husband at the time, but also she was fearing honor crimes and being killed by the uncles who forced her because she was fleeing from the forced marriage. And here we see a myth entering that it is a common belief that rape often occurs in public settings. The very stereotypical rape of someone being raped by a stranger in a dark alley on the streets, for example. Whereas we see that the majority of sexual violence cases happen in the private sphere, in the domestic setting. And we see the underestimation of this danger in private and family spheres. And here the court eventually decided that the account of the applicant was not credible and that she would find sufficient support within her home country by her private support network. Now, this is a recurring argument made by the court, and these private support networks are often male support networks, and it is assumed that these applicants just can go back and find protection and almost in practice, if we look at it, go into hiding from their persecutors by, within their own family atmospheres. And this private support network identified in that case included the very uncles that forced her to marry in the first place. So this is another example where you see that the family is not a safe space against sexual violence, but unfortunately, the court itself still replicates this kind of reasoning. So I think there's a very big difference between the European courts and CEDAW. But it's maybe also interesting to point out that within both of these bodies, there's a difference between the sexual and gender-based violence cases related to asylum and migration control and those who aren't related to that, so the domestic settings. And I think for both bodies, for the European Court by Jana Wessels and for CEDAW by Catherine Briddick, there have been analyses made who compare these two settings, where we see that the decisions are much less gender sensitive in asylum settings than in domestic settings. So I think there's also an important nuance to make, that I do believe that the information and the awareness raising within CEDAW is of a higher level than the one at the European Court, but still you see this territorial bias almost if you compare these two settings of cases. And I think that the analysis by Briddick of CEDAW dates from 2022, so it's also fairly recent. So it's very important to point out the differences between the two, but also to look within the case law to see that difference.
I mean, as someone who has written a book about the migration case law of the European Court of Human Rights, I'm not particularly surprised to hear that it will be particularly difficult for migrants and asylum seekers to have the European Court of Human Rights debunk the myths which negatively affect them. And in that sense, at least if we can put it that way, gender stereotypes happen throughout society. So there is not this this difficulty of having a court who does not want to take a stand on the human rights of migrants kind of coming into that. Certainly my research definitely demonstrated that I think it was quite a clear demonstration that the European Court of Human Rights was not inclined to begin with to be favorable to really push for defending the human rights of migrants. Right from the start, there was a resistance, which I could not see in the Inter-American Court of Human Rights. In the Inter-American Court of Human Rights, there was really a starting point of saying, well, everyone who is a human being needs to have human rights, and we need to pay attention to the situation in which they are and to their vulnerabilities, etc. And a migrant, by definition, is vulnerable because they're not in their home country. They don't have the same networks. They may not know the language. There are all kinds of difficulties that they're going to encounter. And so they need to be, in a sense, given extra help, which actually has brought me to bring up the Inter-American Court of Human Rights. Would either of you, maybe Elena or Laura, do you have anything to say about the approach of the Inter-American Court on stereotypes?
Yes, absolutely. I think that besides the CEDAW committee, which should always be mentioned because, of course, it has been a key role. Let's not forget about the Inter-American Court of Human Rights. Recently, Laura Clerico has published a comment on one of the judgments of the court, which is Manuela and others, or Manuela and family versus El Salvador. The applicant in this case was condemned to 30 years of prison for homicide, for having had an abortion, even though it was due to precarious health conditions. She had a previous health condition that led to the abortion. And the Inter-American Court judged the case, and in the judgment concluded that the domestic court used gender stereotypes to complement insufficient evidence, and for this reason it violated the presumption of innocence and the right to an impartial judge and the obligation to fully motivate the judgments. So basically, since the doctors didn't look fully into the reasons why this person had an abortion, the conditions in which this fact occurred, they straightly went to the conclusions based on gender stereotypes. This was enough to conclude that they violated the presumption of innocence, and the judgment was not impartial. So this is one example of how the Inter-American Court deals with gender stereotypes, and particularly in connection with evidence, in this case, insufficient evidence, or the lack of will to collect evidence to establish the facts. But there are also other examples about gender stereotypes. So I think this is another important point or jurisdiction where we can look for transformative ways of addressing stereotypes in the future.
Okay, thank you. So let's look at CEDAW, let's look at the Inter-American Court of Human Rights. Now, one of you, Elena, you are talking about mainly gender stereotypes. Laura, your research has a lot to do with asylum seekers. I wanted, in a sense, to have an episode having to do with stereotypes. Is it by chance that I kind of put together someone working on gender and someone working on asylum? Or do stereotypes also affect a broader range of social groups? Or was I bound to end up with the two of you?
Do you want to start first, Laura?
Yeah, just a quick answer. I think, no, I don't think it's by chance. I think those are two very big groups about whom a lot of stereotypes exist. But of course, there are others. I can think, of course, about racial stereotypes, stereotypes about persons with disabilities, and so on. It's not the focus of my research, but I feel like all groups about whom, or they are minorities in quantity, or there is just not enough knowledge about this group, which of course leads again to stereotypes which are rooted in truth but not the complete truth due to lack of knowledge. And then you have, of course, the whole creation of stereotypes again. So I think it's characteristic for phenomena and groups who are a minority or about whom there's not enough knowledge to make correct decisions.
Do you want to add anything, Elena? Or
no, I agree. And unfortunately, at the European Court of Human Rights, we have examples of cases that deal with stereotypes on different oppressed groups. So on disability, disabled women with disability, on LGBTIQ minorities, and of course on race and racism. And I think it's not by chance that stereotypes are connected or connected to oppressed groups or groups that are not in a privileged position in the social hierarchy. And I think this is what also distinguish stereotypes from other forms of generalizations, the fact that they are generalizations, but connected to specific groups and with the function of reinforcing the undervalued position of these groups in the social hierarchy.
cannot a stereotype be praising and be helpful? And
Well, I cannot think of an example, and even if they are praising, they don't come with positive consequences. They're sort of even this praising, or so to say, praising characteristics, for example, that women are nurturing or that are less violent. They don't come with I don't know, positive effects, but rather the opposite.
okay. Yeah, I guess that maybe we're not looking into that. I mean, I cannot help thinking that maybe that could exist.
I think in a certain contexts, that might be the case. Maybe what I mentioned before, like stereotypes create a certain image of reality, and I'm sure that some people fit the stereotype, and in that sense they would benefit them, especially if you think about like the limited legal settings. Like I said, an asylum seeker who completely fits the stereotype might benefit. This is something that the TIC team wrote about a lot, how we have these exceptions for the extremely vulnerable, which of course, like you said, Elena, if you look at the bigger society, they are detrimental because they result in the fact that all the others not fitting the stereotype or not fitting this exception don't get protected. So yeah, but then still, if I look at the culture in asylum settings today, even these extremely vulnerable who fit the stereotype don't get protected for other reasons. There's always something that renders the whole story not credible, or there's some other reason why they shouldn't be protected. So I feel like maybe it has in the past, but in the asylum setting, at least for what I know, yeah, I can't think of many examples.
Yeah. I mean, obviously, Laura, you are working with a group of people who are particularly kind of demonized, and it's very difficult for them to get their rights recognized. So anyway, maybe I was opening up too much. I also can see that we have members of the audience who are very much wanting to come in, and you will come in within shortly, but not yet. I think what I would like to what struck me as well, we're talking about the polluting effect of stereotypes on evidence, and that is very, very important to highlight. But I also have one member of my DISSECT research team, Emma Varnaghi, who is a PhD researcher, and what she highlights is that she would like the European Court of Human Rights to pay attention to stereotypes, not because to eliminate them because they pollute evidence, but because they would in themselves be a piece of evidence if uttered by the police, by the authorities. She's working on violence by the police against Roma people, that if these stereotypes about the Roma people who are uttered by the police authorities were taken into consideration, they could in themselves be used as evidence that something has gone wrong, that there is a discriminatory underlying practice going on. So that is interesting. And I mean, obviously we are back into these stereotypes, which are in themselves either a manifestation of discrimination or triggering discrimination themselves. But there is this very troubling relationship that we need to think about. Is there anything, Laura or Elena, that you would like to add to this conversation before we bring it to a close?
I think maybe we talked about what the solutions are, or what the way forward is, or what the good practices are. So maybe just to close off on a more uplifting note, yeah, I feel like the whole point of these stereotypes is that they are so entrenched in society that they are not always conscious. So I think we need to take into account that it's not always bad faith, but that they're so natural to the way we think at one point, that we need to actively remedy them. And that's why the practice you spoke about within CEDAW to inform the members by literature is so interesting. And I think that's the way forward. I think it's just important to raise awareness on how, or on the limited nature of these stereotypes. And I think in that sense, trainings and awareness raising programs for decision makers are a very important thing to look into if we consider what to do about this, because I think that's in the end the point of talking about it, right? Talking about the problems, but also how to remedy them. So
Elena, anything you wish to add?
No, I agree with Laura. I think that we need to keep researching on these stereotypes, because it seems like we are every time closer and closer to understanding exactly what they are and how they work, but they keep being very elusive, particularly if we want to make them operative in legal reasoning. So understanding the difference between stereotypes and generalizations, being more strict with this distinction. We still have, I think, we are still missing some pieces of this puzzle, but I think it's always very interesting to bring together different perspectives and keep working on that.
Okay, well, in that case, I'm going to wish you really good progress in your forthcoming research. I'm going to stop the recording for now, but we are going to carry on with questions from the audience, but outside the recording part of this conversation.